The Supreme Court just made a critical decision that affects state gun rights protections across America. Missouri's Second Amendment Preservation Act faced a major setback. But here's the twist. The Trump administration made a promise to the court that they still haven't kept. Let me explain what just happened, why it matters, and what could happen next in this developing story. A significant ruling just came down from the Supreme Court regarding state-level Second Amendment protections. This decision impacts how states can push back against federal firearms regulations they believe violate constitutional rights. Let's start with the background. Missouri passed legislation in 2021 called the Second Amendment Preservation Act. This law represented the state's effort to protect gun rights by limiting cooperation with federal enforcement actions that Missouri believed violated the Second Amendment. The law worked in a specific way. It prevented Missouri law enforcement officers, government agents, and state officials from assisting federal authorities when those federal agents were attempting to enforce gun laws that the state deemed unconstitutional. Essentially, Missouri said its resources and personnel would not support federal actions it disagreed with. The law also included an interesting enforcement mechanism. Any Missouri resident could file a civil lawsuit against a state official who violated this prohibition. If a state employee helped federal agents enforce what Missouri considered unconstitutional gun laws, citizens could take legal action. This put enforcement power directly in the hands of residents rather than relying on state prosecutors or government oversight. The federal government challenged this law immediately. During the previous administration, the Justice Department filed a lawsuit arguing Missouri had overstepped its authority. A federal district court agreed with the government and struck down the entire law. The court issued a complete injunction preventing any part of the Missouri law from taking effect. Missouri wasn't ready to give up. The state appealed to the Eighth Circuit Court of Appeals. They also requested a temporary stay, asking the appeals court to pause the lower court's injunction while the case proceeded. This would have allowed at least portions of the law to operate during the legal battle. However, the Eighth Circuit declined to grant that stay. With the injunction still in place and their law completely blocked, Missouri made an emergency request to the Supreme Court. They asked the nation's highest court to intervene and temporarily allow their law to function while litigation continued. The Supreme Court responded with an 8-1 decision denying Missouri's emergency request. Only Justice Clarence Thomas voted in favor of granting the stay and allowing some aspects of the state law to proceed. The other 8 justices sided against Missouri's emergency application. After that initial Supreme Court denial, the case returned to the Eighth Circuit for full consideration. The appeals court reviewed the arguments from both sides and ultimately sided with the federal government once again. They struck down Missouri's Second Amendment Preservation Act in its entirety. Missouri then petitioned the Supreme Court for a second time, seeking full review of the case. The state raised several important constitutional arguments about why the Eighth Circuit got it wrong. One key point Missouri emphasized was the appeals court's reasoning. According to Missouri, the Eighth Circuit acknowledged that the structure and potential operation of the law was constitutionally valid. However, the court struck it down anyway because they objected to its underlying Second Amendment purpose. Missouri argued this was legally inconsistent. Missouri also challenged how the Eighth Circuit interpreted enforcement. The appeals court ruled that state officials could be sued under the law because simply complying with state law amounted to active enforcement. In other words, the court found that non-action or compliance with state directives constituted enforcement activity. Missouri argued this stretched legal concepts beyond recognition. The case began under one administration but transitioned to another. When the current administration took control, something interesting happened. Instead of immediately taking a position, the Justice Department stalled for several months. Legal observers waited to see whether the new administration would change course. Finally, the Trump administration filed their brief. They continued arguing that Missouri's law was invalid in most of its applications. They told the Supreme Court that the lower courts had reached the correct decision in striking down the law. However, they added an important caveat. The administration stated that if the Supreme Court denied Missouri's emergency review request, they would take action once the case returned to the district court. Specifically, they promised to narrow or dismiss portions of the total injunction that had been obtained by the previous administration. The Justice Department's brief explained their concerns. They wrote that upon reevaluation, they had doubts about whether the lower court's judgment extended too far. They questioned whether the injunction blocked applications of Missouri's law that should be protected under the anti-commandeering doctrine. The anti-commandeering doctrine is an important constitutional principle. It prevents the federal government from forcing states to enforce federal laws. States can choose not to use their own resources to help federal enforcement efforts. The Trump DOJ suggested that some aspects of Missouri's law might fall under this protected category. They also noted uncertainty about how certain provisions would actually be applied. Because this was a pre-enforcement challenge, meaning the law hadn't actually been implemented yet, there were questions about real-world applications. The administration expressed concern that the appeals court may have improperly bundled together separable provisions. Based on these concerns, the Justice Department told the Supreme Court they would agree to narrowing the injunction's scope once the district court regained jurisdiction. This was essentially a promise: deny review now and we'll provide some relief later at the lower court level. Missouri responded to this concession strategically. The state argued this was precisely why the Supreme Court should grant review. If the administration was admitting problems with the lower court ruling, the Supreme Court should address those issues directly rather than relying on future promises. Missouri also raised concerns about whether the administration would actually follow through. They questioned whether the Justice Department would truly narrow the injunction once the case left the Supreme Court's oversight. It's easier to make promises than to keep them, especially when political winds shift. Despite Missouri's arguments, the Supreme Court sided with the administration's position. In their recent order, the court denied emergency review of the Second Amendment Preservation Act case. They declined to take up Missouri's petition, which means the case would return to lower courts. This denial is now official. The Supreme Court has notified both the Eighth Circuit and the Missouri District Court that the case is closed at the Supreme Court level. Jurisdiction returns to the lower courts where further proceedings can occur. Here's where things get interesting and concerning. The Trump administration made a specific promise to the Supreme Court. They said that once the case returned to the district court jurisdiction, they would move to narrow or dismiss the broad injunction. They would allow certain aspects of Missouri's law that fall under anti-commandeering protection to potentially take effect. However, months have passed since the Supreme Court's denial, and the administration has not yet filed any motion to modify the injunction. The district court still has the complete injunction in place, blocking Missouri's entire law from operating. No action has been taken to fulfill the promise made to the Supreme Court. This creates several questions. Will the administration follow through on their commitment? Was the promise made in good faith, or was it simply a tactic to convince the Supreme Court to deny review? What recourse does Missouri have if the federal government doesn't act? The legal community is watching closely. Trust in government representations to courts is fundamental to the judicial system. When parties make commitments to influence court decisions, those commitments matter. Failure to follow through could have implications for future cases. For gun rights advocates, this case represents an important test of federalism principles. Can states protect rights they believe the federal government is violating? What are the limits of state resistance to federal enforcement actions? These questions extend beyond just firearms to many areas of law. The anti-commandeering doctrine has been recognized in Supreme Court precedent. States cannot be forced to use their resources and personnel to carry out federal programs. This principle has been applied in various contexts, from immigration enforcement to environmental regulations. Missouri's law attempted to leverage this doctrine specifically for Second Amendment purposes. The state argued it had no obligation to help enforce federal gun laws it considered unconstitutional. Whether courts will accept this application of anti-commandeering principles remains an open question.
The case also raises issues about judicial review of state laws with controversial purposes. Can courts strike down otherwise valid state actions simply because they disagree with the underlying policy goals? Missouri argued the Eighth Circuit did exactly that, finding the structure valid but the purpose objectionable. Looking forward, several scenarios could play out. The Trump administration might eventually file their promised motion to narrow the injunction blocking the law. The district court would then decide which portions of Missouri's law, if any, can take effect. Missouri could also pursue additional appeals depending on how those proceedings develop. Alternatively, if the administration never acts, Missouri faces a more difficult path. They've already been denied Supreme Court review twice. Returning to the Supreme Court a third time would be challenging without new developments or arguments. Other states are watching this case carefully. Multiple states have considered or passed similar Second Amendment preservation laws. The outcome here will influence whether other states pursue this approach or try different strategies to protect gun rights. The broader constitutional questions remain unresolved. How should courts balance federal supremacy against state sovereignty? When can states refuse cooperation with federal enforcement? What remedies exist when federal actions allegedly violate constitutional rights? The Supreme Court has denied Missouri's Second Amendment Preservation Act case, but the story isn't over. The Trump administration promised to narrow the injunction blocking the law, yet months later they haven't acted. This leaves Missouri's gun rights protections in legal limbo while raising questions about government commitments to courts. The outcome will impact not just Missouri, but other states considering similar approaches to protecting constitutional rights against federal overreach.